The rules regarding client engagement under the American Bar Association. Once a lawyer is licensed to practice law in a state, she can take on cases involving almost any type of legal matters. There is an exception for patent prosecution, and a separate license is required for patent attorneys. But a lawyer with little or no experience in an area of law can take on a case in that area if the licensed attorney is able to read up on the area and become competent through study. If a good faith argument can be made that the law should be changed, a lawyer is even able to take on cases that are impossible to win unless the law is in fact changed. A lawyer has the duty to reject a case or client assignment when acceptance would force the lawyer to break a law or an ethics rule, when the lawyer is incompetent in the matter and unable to become competent anytime soon, the lawyer is too busy to provide effective representation, the case is intended to harass or maliciously injure a person, or the lawyer is so personally offended by the case that he is rendered unable to represent the client effectively. The court has to appoint clients to attorneys, even clients that are unpopular or too poor to pay. The attorney is required to accept a fair share of such clients. The lawyer can seek to avoid such appointments only for good cause. Examples of good cause are situations where the case would impose an unreasonable financial burden on the lawyer, accepting the client would force the lawyer to break the law or an ethics rule, or where the lawyer's personal beliefs would render him unable to provide effective representation to the client. This may come about where the lawyer finds the client's case so repugnant that the lawyer is unable to represent the client effectively. A lawyer must withdraw from a case or assignment if the lawyer is fired by the client's only purpose for retaining the lawyer is to delay or harass, continuing with the assignment would require a violation of law or a disciplinary rule by the lawyer, or the lawyer is too sick to represent the client effectively. On withdrawal, the lawyer has certain duties to the client. The lawyer must provide reasonable notice to the client so that the client has the opportunity to find alternative representation. Of course, the lawyer has a duty to refund any unearned advances and fees and unspent advances of expenses. The lawyer also is required to hand over all the client's files, papers, and property. A lawyer is not required to withdraw, but may withdraw from the case or assignment under the following situations. If the client freely agrees to the withdrawal, the client's lack of cooperation prevents effective representation, the client lies or breaks a promise to the lawyer, the client is pursuing future criminal or fraudulent conduct, the client has used the attorney's representation to perpetrate a crime in the past, the lawyer finds the client or the cause repugnant, the client fails to pay the lawyer's fees, or the case places an unreasonable financial burden on the lawyer. In these situations, the lawyer has a right to withdraw, but is not duty-bound to fire the client, and can continue to represent the client if she wishes. Once in litigation, a lawyer must request court permission before withdrawal from a case. This holds true in all situations, even when the lawyer is duty-bound to withdraw and could be subject to discipline for failing to withdraw. Concerned about undue delay or disruption to the case, the court is reluctant to allow the lawyer to pull out after the case is in trial. In fact, the court often refuses permission for withdrawal, even when good cause is presented by the attorney.